first felony offender. Offense, manslaughter. Parole date is August 1st, 2021. Good time, March 5th, 2033. Full term, February 28th, 2040. Is this information correct?
Yes, ma'am.
Thank you. Mr. Marabella.
Thank you very much. Ms. Payne, my name is Tony Marabella. Your case was assigned to me, so I will be the panel member to begin to talk with you. Can you hear me okay?
Yes, sir.
How old are you, Ms. Payne?
I'm 47.
Okay. And how long have you been in prison on these charges?
Almost 22 years.
Ms. Payne, I have read your file. I've looked at all of the things you've accomplished, and we'll talk about those in just a few moments. I'd like to talk about what was going on with you when all of this occurred, when young Sahara was killed. So tell me what was going on in your life at that time, and how did this happen?
I was very young at the time, not prepared to be a parent as I thought I was going to be. I grew up in a household that used physical discipline, so I thought that was just the way that things were done. I know now that I didn't have enough coping skills to deal with a lot of the issues that were facing me at the time as somebody, as a first-time parent. And I can't make an excuse for what happened. It's just that I've spent a lot of time looking at myself since then to figure out what went wrong and trying to change that. But mainly it was just my inexperience and my lack of coping skills.
And how old were you at the time this happened?
24.
Okay. Now, you obviously knew you shouldn't be beating on a 2-year-old child. So, I mean, can we both accept that that's true?
Yes, sir.
Okay. Now, that wasn't your first experience of abuse with Sahara, was it?
No. We used physical punishment.
Okay. I read your application, and I have a question and I have a concern, and maybe I misread it. So I do see where you accept responsibility for what you did, but you also, at least in my reading of it, suggest that maybe the hospital was a little bit at fault because they didn't have the proper equipment to perform surgery on Sahara. Tell me whose fault this is that Sahara was killed.
I have to take responsibility for this, sir. The hospital did what they could. I'm sure I wasn't there, but this is nobody's fault but mine.
Tell me how you have changed. I mean, you've done a lot of good, positive things, and I understand that. Tell me how the 24-year-old woman who committed this crime has changed, and what you've come to learn about what you did and why it's not likely to happen again.
I think I had to be willing to, first of all, face up to what happened and the crime that I committed. I had to be willing to look at myself with all honesty, and then I had to be willing to ask for help from people that were qualified to give it to me. I spent almost 3 years in one-on-one counseling. I took parenting classes, I've taken substance abuse classes, anger management classes, and I've been involved in several faith-based programs. But just learning those different coping skills and stress management skills and about triggers and how to control my temper, and mainly just being willing to deal with self and being willing to change all the things that I could in order that nobody else ever be hurt again because of me in any way.
What are some of the most significant programs that you've taken that you believe have helped you the most?
I earned a bachelor's degree in communication because I believe that had I had different communication, better communication. Some of this could have been prevented, maybe all of it. And so that was important to me. Becoming a sign language interpreter was important to me because it gave me a different viewpoint on somebody else's culture, a different type of empathy for people that are not always to the forefront of society. And I just completed life healing choices. And instead of just giving advice, it really gave you practical application on how you can choose to do something other than what you've always done before. So those are some of the most important things that I've taken.
I believe I read throughout your file that not only are you a sign language interpreter, but you're a tutor for them and you work with them. Is that correct? How has that made you a different person working with persons who have difficulties? And I want to say this, it means a lot to me because I have a number of deaf people in my family over the years, and I have a soft spot for people who have worked and helped them. So tell me how you felt about working with them and helping them.
I believe that, for one, everybody should have an equal opportunity. They should have equal access. And some of the opportunities that are denied to people are denied to them because they're not qualified or they don't have the educational background to get it. So when people come in here and they don't have a GED yet, one of the most important things that I think most of the tutors feel, but me especially, we can do to help people is make sure they have a tool to go out of here with, a foundation, so that they can make other choices other than the ones that they came in here with. It broadens your horizons. It gives you a chance, the one that you didn't have before, maybe.
Tell me the different jobs you've had while you've been in prison, and which one do you believe is the better one for you, or what the one that you have believed that has benefited you the most?
I think, well, I've worked as in maintenance. I've worked as a baker in the kitchen. I've worked as a housekeeper, a groundskeeper, greenhouse worker, in the laundry. I've been a student in welding, office occupation, horticulture, but most fulfilling for me has been being a tutor, and I've done that on and off since 2009 for different classes.
Do you have trustee status?
I do.
How long have you been a trustee?
A while now. Yeah, they said there isn't a date by it, but a while now.
4 years, 5 years, 6 years, 8 years, 2 years? Just in general.
About a year.
Okay, all right, okay. Now, you've indicated in your application, and I've seen it in your record, that maybe you were abused as a child, that there were some mental, emotional issues involved. How have you been able to deal with those, and how do you anticipate dealing with those if you have an early release?
The first thing that had to happen was I had to realize that not everybody operated that way. That was just the way that I grew up. So that was normal for me. My mother had bipolar disorder, and that was just how we lived. That was our normal. It just wasn't until later on, talking to other people, that I realized not every family operated like that. Not every family handled things the same way. And so in prison, you learn a lot of self-control. You have to have self-discipline to survive in here. You have to obey rules, maybe that you don't want to. You have to listen to authority, and you have to deal with other inmates 24 hours a day. So for me, it was just understanding that there were other options available to me. I didn't have to do what I grew up having done to me. And I'm not putting the blame there. I just had to realize that there were other ways to do things.
Tell me a little bit about what you hope to do if you get an early release. What is your transition plan?
Initially, I would like to go to the Parole project. I know I've been down a long time. I came to jail with a beeper, so a lot has changed. And so once I've completed their program, I would like to transfer to Shreveport. I have plans to start a horticulture business. I took entrepreneurship classes and business classes. I have a business plan. I registered my LLC with the state. I have a tax number, but I would like to work with people that were formerly incarcerated and hire them. But first, I'd like to mentor with an established landscaping business so they can show me the ropes. But I have some connections that are willing to work with me, and that's what I would like to do is catch women coming out of prison and hopefully give them a decent job, and myself.
What would you say to Sahara if you could say something to him today?
I would tell him it wasn't his fault. And I would tell him that I loved him and I was so sorry. I would take his place if I could. I wished I could. I've been over that day every day. There's so many things that I would do differently. He didn't deserve what happened. None of that was anybody's but mine. And I'm sorry I let him down. I hope he forgives me.
Thank you, Ms. Payne. You do have, just for the record, you have a low risk assessment. You have low needs. You've got a good transition plan. Warden, can you tell us anything more about Ms. Payne?
Just to mention a few things, I know we went over her numerous programs that she's been in, and she's received her degree, and she's become a tutor, and she's minimum status. She did have a few write-ups early on, but even with the write-ups she had, they were lower level, they were suspended sentences. She hasn't had any write-ups since 2016, and she has been assisting the offenders where she could on different, with the sign language program and through education. She has, numerous classes, kind of like everything that she could do, she has done with us, welding and, so she has, I would think, the skills needed to make it out on the outside if she went with the parole project for them to help her transition, because things have changed over the last 20 years.
Thank you very much, Ward. I do have another, I didn't cover this and I don't know that I had much information on it. Tell me a little bit, if you would, Ms. Payne, about, let's see if we can flip the camera back over to Ms. Payne. There you go. Ms. Payne, tell me a little bit about drugs or alcohol. Were you using drugs or alcohol back during this time?
The only drugs that I had were prescription drugs. At that time, I had a lot of health problems. And so I suffered with chronic migraines then, which seems to have resolved itself since then. But I did have medication in my system at the time of the crime because of that. But as far as like illegal drugs or alcohol, no.
Okay. And are you currently on any medication, prescription meds that you take now?
Right, but none of them are the psychiatric drugs, none of them, it's all, it's blood pressure, standard stuff.
Okay. During the course of your stay in prison and perhaps having mental health evaluations, have you ever been prescribed any medications while you've been in there? Okay. Thank you. That's all the questions I have, Madam Chairman. Thank you.
Thank you, Mr. Marabella. Ms. Teresa, could you introduce our guests?
We will first start with Mr. Andrew Hunley from Louisiana Parole Project, who is in support.
Good morning, Andrew Hunley, representing Louisiana Parole Project. We wanted to inform the board that ALAIRIS is a client of our organization. If she's granted early release, we will provide the full support of our program to her. She will be initially housed at redemption homes and she will take part in our reentry program, where we will help her learn technological skills, consumer skills, reintegrating with her family. We will also provide her support to meet her healthcare needs. She will receive a mental health assessment immediately upon her release, and our organization will work with her to follow up on any recommendations that are stated in that assessment. Our organization feels confident in ALAIRIS's ability to be successful based on her institutional achievements and her ability to grow during her time incarcerated. Even at the point that she would leave our program, we would continue to provide case management to ALAIRIS, which would include peer mentorship, but also support through our volunteers in the community. Our organization looks forward to working with ALAIRIS to rebuild her life if she's given this chance. Thank you.
Thank you. We will now hear from Ms. Patricia Williams, who's a friend.
Good morning. My name is Patricia Williams. I'm speaking in support of ALAIRIS Payne. ALAIRIS and I met over a decade ago while I was incarcerated at St. Gabriel. And what ALAIRIS taught me is to get up and do my time, to be proactive in my community, and be a positive influence. And through ALAIRIS, I learned also to face who I was and who I wanted to become. I watched ALAIRIS as she was an academic tutor. She helped people, we tutored together, and I watched her teach women who could barely read, who could barely write, do basic math, and then to watch the light coming on their eyes as they got their high-set diploma. Then as she was a student in horticulture and became an instructor. Prison can be a really dismal, gray place. But for her students in horticulture, they learn to grow things with their hands, work with their hands, see something bloom, and make something beautiful in a really dismal place. That's what happens to us when we go to prison. We come with a lot of grief, a lot of guilt. And if we work on ourselves, we can turn those horrible, challenging times into something of beauty because we've learned. I watched her become an American Sign Language interpreter. We also took those same classes together. And she has always wanted to help others. That has always been her goal. And then she graduated from the University of Ashland. She was in the documentary of Life of Christ at Angola. Her goal was always to obtain skill sets to use when she got her second chance and to use those skills to help others. When she's released and she completes the parole project, she will have a home with me if she chooses in Caddo Parish. I am the manager of the Exit 318 Reentry Program in Caddo and Bossier parishes. I have the resources that can help her be successful when she comes to Caddo Parish with employment, mental health, transportation, pro-social activities, to get involved in groups such as Hope Connections, helping the homeless, the veterans, reentry. Northwest Louisiana Reentry Coalition is in Caddo Parish and has been here for 20 plus years. And she has a huge support group that will make sure that she can reacclimate into the community, be successful, be an asset to the community. And my hope is that the board will vote for ALAIRIS Payne to get her second chance. Thank you.
Thank you. We will now hear from Ms. Consuela Gaines, who's a friend.
Good morning. I'm Consuela Gaines, a friend of Ms. ALAIRIS Payne. Like Patricia, I met ALAIRIS while I was incarcerated at LCIW. I spent 22 years there, and the majority of it, I had the opportunity to work alongside of ALAIRIS on many, many occasions. I have to say that, like Patricia, she is someone who is always encouraging others. bringing out the best in other people. She certainly taught me a lot about myself and helped me to be the best person that I could be in moments when I wanted to give up. ALAIRIS was one of the main people who encouraged me not to. She's one of the most honest people I have ever met in my life. I can recall times of just sitting and talking about life in general. And she was always so brutally honest. She is one of those friends that you want to have around because she's not going to tell you what you want to hear, but she will tell you what you need to hear. And she's always so giving. She's always so willing to help other people. She sees potential in people, just like she can cultivate plants and things like that, which I never could. I don't have a green thumb like she does. She's the same way with people. She's so loving and nurturing. And I'm like, I couldn't believe that she was someone who was incarcerated, but the spirit that she has is very gentle, is very passionate, and very loving. And she always worked extremely hard to better herself. Like me, she is the type of person who believes in becoming better every single day. Every day, she's thirsty for knowledge. And she was always at the top of her class, just about in anything, sign language, horticulture. She graduates with honors. That's because she really pushes herself to be the best person that she can possibly be. And I just ask that this board take into consideration all of the wonderful things that she has accomplished, the fact that she has accepted responsibility, and give ALAIRIS an opportunity to re-enter society. And I thank you.
Thank you. We will now hear from the opposition side, Ms. Brenda Onisha, who's the victim's mother.
Hello. Hello.
Yes, ma'am. Tell us what you'd like us to know. Go ahead. We can hear you.
Yes, ma'am. I would just like to state that with all the good she's done, having free school, free shelter, free rent when she gets out, she's still taking away a child from a mother. She has taken away a brother from my two daughters. Even in foster care, at the age of 18, they would have still had the chance to meet their brother. And they'll never get that now. I'll never get to see my son again. They'll never get to meet their brothers. My grandchildren will never meet their uncles. It's put me through a 10 to 20 years of just grief. It led me to get on drugs. It led me to go through a lot of obstacles in life that would not have been there had this not had happened. I'm sorry, I really can't speak right now.
It's okay. We appreciate
But it's just
you.
a lot that she's taken from.
Yes,
Okay.
ma'am. And we appreciate your participation this morning. Thank you so much. Ms. Payne, before I turn it over to your attorney, is there a statement you'd like to make to the parole panel?
Yes, ma'am. Thank you for hearing me today, first of all. And I know they're not adequate words. I can't express the amount of sorrow and remorse that I felt for the crime that I committed. She's right. I did take somebody's family from them. And I hope one day that she does rebuild her life and she will be able to forgive me. I know the board has a very difficult decision to make. I don't know how those decisions get made, but I'm throwing myself upon the mercy of the board. And if given the opportunity, I plan on dedicating my life, giving back to my community. It won't fix what happened, but I can't do anything about that now. All I can do is be somebody other than the person that I was then. I can't give his life back. I wish I could. I wish I could. Thank you.
Thank you. Mr. Nordike.
Thank you. Listening to all of this today led me to think something that I guess I've known but haven't articulated, and that is that unlike a lot of what we do in the law business, parole is a forward-looking device. It is somewhat retrospective, but it, for the most part, looks forward because the panel has to make decisions going forward. How will this person do? I was fairly recently retained to work with ALAIRIS on her pardon application, which became an Act 122 parole. But I have known ALAIRIS for 6 or 8 years, I guess, maybe longer, because we have been in correspondence for that long. She was looking for my assistance on some other issues that far back. And what you see today is what you get. That's what ALAIRIS has been the whole time I've known her. She is a trustee. She's been down 22 years. She's a low risk. And let me tell you from the research, females almost never come back. Females of her age almost never come back. And then when you throw in the mix, her offense, it is almost a slam dunk that she will never come back. She is almost recidivism proof at this state. She's gone through and gotten an education. I don't know what to tell you other than ALAIRIS said it best. She came into prison and started working to fix what was wrong with her. And I think she's done a magnificent job of it. She's taken every course that she needs to succeed on the outside. And she has taken give back courses, such as tutoring. She's done good give back stuff, such as tutoring and sign language. She's amazing diversity in what she has learned: horticulture, sign language, and welding. I'm not sure how welding fits into the mix, but she's done it all. And with all of that, I think she's postured to succeed, and I would ask for release to the parole project.
Thank you, Mr. Nordike. I think we're prepared to vote. We'll start with Mr. Marabella.
Thank you, Madam Chairman. First off, I'd like to say to Miss Anisha, I certainly appreciate the courage that it took you to come here today to speak and express your grief, and we certainly understand that. If there was anything, if my vote could in any way bring back your son, my vote would do that, but it can't. And of course, our job and what we are here today is to determine what Ms. Payne has accomplished, what has gone on with her since that day. Hopefully our prison system for those who try is rehabilitative. I think that we have 3 clear examples of that system on this YouTube today. Testifying here today on Ms. Payne's behalf. People who go to prison can become better people. They can learn. It takes work and it takes hard work. Ms. Payne has put in that hard work. The comments from her supporters, the warden comments, the good programs that she's done. She is a low risk. She's got an excellent transition plan. She's got an education. She has done some phenomenal things while she's been in prison. That does not excuse what happens. And she's not asking here today to be excused. She's accepted responsibility for it. I was a little concerned about her comments about the hospital, but I understand that perhaps if there had been more availability there, something different could have happened. But she explained very satisfactorily to me what the concern was. My vote today is going to be to grant her pardon of her parole to the Louisiana Parole Project. As Mr. Hunley pointed out, they already do a mental health evaluation and file a recommendation. That would be one of my conditions as well. I would also like, even though Ms. Payne indicates she has no substance abuse issues, I'd like a substance abuse evaluation done as well, and any recommendation followed. I would also like that she have a curfew from 9 to 6. So that would be my vote. Ms. Payne, good luck to you, man.
Thank you. Thank you, Mr. Marabella. Ms. Wise?
Ms. Payne, I had an opportunity to read a lot of material that was presented on your case, and I just want to commend you on who you have become today. Yeah, you've really done some good work. I concur with my colleague. My vote is to grant for the reasons already been stated, and I concur with the special conditions that's been outlined. Best wishes to you, ma'am.
Thank you.
Thank you, Ms. Wise. All right, Ms. Payne, I do agree. I think you've laid out a very reasonable transition plan. So my vote also is to grant to the Parole Project for the reasons that have already been stated with the same special conditions. Good luck to you, ma'am.
Thank you.
Thank you, board.
You know what I think we're missing in this hearing? And what we're missing is the assistant DA. What we're missing is a victim's advocate. This poor mother came in here all alone while everyone else is stacked up against her. And it's like we are forgetting about the 2-year-old boy. The 2-year-old boy whose life was ripped away by his caretaker. It hasn't even been, what is it? This crime happened in, we're going to go over the information, February 23rd of the year 2000. And this hearing happens in January of the year 2021. It's been 21 years. What happened to 25 years for taking a life? What is it, because it was a 2-year-old baby? It doesn't need to be 25 years anymore? Explain that to me. And what remorse did you see anyways? I thought it was awful when she had to describe what did she say? She said it wasn't his fault. If I could tell him anything, I would tell him that it wasn't his fault. He didn't deserve what happened. It was my fault. And frankly, who says that? It wasn't his fault? No, why would it be his fault? When someone says that, it shows insight into how they think. And from what I see, how she thinks is she still thinks that it was his fault. If she actually has to make the ridiculous statement that like that. Oh, it's my lighting. It's unreal. But now let's go dive into so you can get the details of what she did. Now this appeal is actually, it's quite interesting. They appealed to throw out her confession when she confessed in the crime because she had said that it was whether or not her confession would be admissible. And the reason why is she said, may I call a lawyer or can I call a lawyer? And initially the judge ruled that her confession would not be admissible because of those words, but then they threw it out and said that it was that her confession should be admissible. And I think that's an interesting point, right? Or at least topic. Let me see if I can make it so that it's a little bit easier. So on February 23rd, year 2000, doctors at the medical center summoned the police department to investigate possible child, abuse. The 2-year-old child, 2 years old, it wasn't his fault, right? That's what she says 20 years later. It wasn't his fault. Had been brought to the emergency room by his foster father, Andrew, in an unconscious condition. Dr. Gordon Webb, the attending emergency room physician, noted severe head injury compatible with blunt force trauma. Multiple bruises and abrasions of varying ages suggested repeat trauma. Bruises of multiple times interval and over many parts of the body suggestive of physical abuse. The child was transferred to the pediatric intensive care unit and underwent surgery to remove a blood clot from his brain. The child was placed on life support, but passed away 4 days later on February 7, 2000, as a result of his injuries. An innocent, vulnerable 2-year-old who cannot defend himself, who cannot do anything to protect his little fragile body. And she says 20 years later, it was not his fault. That's what I would tell him. You idiot. It's the best you can come up with. Low risk score, deserving to be free. That's the best you can come up with. On February 23rd, 2000, after taking the initial child abuse report at the hospital, the police went home to the home of Andrew and ALAIRIS, the Paynes, or foster parents, not only to the injured child, Sahara, but to also a 6-week-old infant. If you have such major anger problems and where you don't become a foster parent. That's the thing. They didn't just become foster parents because I say there's more evil here. I say that this was some type of fantasy that she wanted to play out, so she became a foster parent. Just my opinion. But the same way there are people that hurt children to do things to them of other natures, there are same, I think, that do this to physically harm them. 6-week-old. If you can't control yourself and you were brought up in a home where what she was saying, physical abuse was the norm, then what are you doing becoming a foster parent? Lasting pain, huh? But also a 6-week-old infant. Upon arriving at the Payne's residence, Detective Joseph Thomerson informed Payne that the police department was investigating the injury to Sahara, and they needed to speak to her at the police station. The police entered her residence and presented her with the consent to search, which she signed. The defendant also advised her of her Miranda rights by Detective Thomerson, a signed written rights form. Later, Detective Thomerson transported defendant to Bossier City Police Department. It is undisputed that he did not attempt to interview or interrogate the defendant. She was neither handcuffed nor placed under arrest. When the defendant arrived at the police department, she waited in the break room approximately 15 to 30 minutes until she was interviewed by the detective. Defendant was again informed of her Miranda rights and gave the first of the 2 tape recording statements. In the first statement, the defendant did not admit to intentionally harming the child. Detective Thorpe then met a second time with the defendant, and he again advised her of Miranda rights. He told her of the surgery to remove the blood clot from Sahara's brain in the second tape statement. The defendant confessed to injuring Sahara. She stated, so in the second recording, she stated that she had a migraine, and while bathing the child, she and the child had struggled. You see that? There it is. There it goes back to it wasn't his fault. She struggled with the 2-year-old. Defendant claimed the child pulled her into the bathtub during the struggle. Yep. The 2-year-old pulled her into the bathtub during the struggle. The defendant claimed the child pulled her into the bathtub during the struggle, whereupon she grabbed the child by the right side of the head and banged the left side of his head against the bath wall approximately 3 times. Bang, 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 a 2-year-old's head. If I could fix what happened, I would. I wish it didn't happen. It wasn't his fault. These are words of someone who deserves to be free. She also confessed to abusing the child in the past. Detective Stewart received consent from the defendant to conduct a videotaped walkthrough of the residence in which she explained how she had battered the child prior to conducting the videotaped walkthrough. Defendant signed another consent search form. Really, she should be set free after serving 20 years, 21 years. After defendant was arrested and indicted for first degree, she filed a motion to suppress statements alleging the detective coerced her statements from her by use of intimidation. Really? The defendant later filed a supplemental and amended motion to suppress statements alleging she tried to call her attorney before going to the police station February 23, 2000 by using a cordless phone, which one of the police officers took away from her. Defendant claims the subsequent interrogation was conducted in violation of her invocation of her right to have an attorney present during questioning. The trial court conducted a 2-day hearing on the motion to suppress. At the hearing, the crucial issue was whether the defendant actually made a request for an attorney, and if so, whether Detective Thomason heard her. The record of this hearing shows conflicting testimony among the witnesses. The defendant testified her close friend Jessica Davis arrived at the house in almost the same time as the police. From what she and Miss Davis led to the patrol car. Defendant stated that she and Miss Davis were trying to figure out what was going on because no one was answering the defendant's question. Defendant testified that she had a cordless phone in her hand and she brought outside with her. She stated Detective Thomason took the phone from her and placed it on the roof of his police car. Detective Thomason turned to speak with someone, and the defendant turned to Miss Davis and asked if she would call John, her father-in-law, who was an attorney in Detroit, Michigan. Miss Davis told the defendant that she could call him, so she picked up the phone from the roof of the police car. Defendant claims Detective Thomason took the phone away from her again and asked Miss Davis to please step over to the other squad car. Defendant stated that she tried to call again. At the point, Detective Thomason took the phone from her and locked her in the police car. Miss Davis testified that the defendant had a phone in her hand with the Detective Thomason. What are they talking about? Miss Davis stated, defendant said, "May I call a lawyer? Can I call a lawyer?" and reached up for the phone. Detective Thomason pushed the phone farther away on top of the car and said, "You don't need this." Detective Thomason testified that he did not hear defendant ask if she could call a lawyer. He stated the last time he saw the cordless phone was when the defendant was inside a residence. In its oral reasons for ruling, the trial court noted the conflicting testimony. The trial court noted Detective Thomason testified the defendant never asked for an attorney. As to defendant, the trial court found she was not credible because she had falsely claimed to have been denied the use of the bathroom and had urinated upon herself. She falsely claimed to have been denied medication for her migraines, and she falsely claimed to have been rendered incoherent by medication she had taken. Because of her credibility was doubtful, the trial court disregarded defendant's testimony. Thank you. The trial court was persuaded by testimony of Ms. Davis primarily because her testimony was neither refuted nor rebutted by the state. In accepting Ms. Davis' testimony, the trial court stated, "We have testimony of a witness, Ms. Jess Davis, who said that Ms. Payne asked for a lawyer. That testimony has not been refuted nor has it been rebutted. Mr. Thomason said that the defendant, never asked for an attorney. The trial court rejected testimony of Detective Thomason and accepted the testimony of Ms. Davis that the defendant had said, 'May I call a lawyer? Can I call a lawyer?' while reaching for the cordless phone. The trial court granted the defendant's motion to suppress all statements the defendant made." So because of this other witness, they actually took her word over the police officer's word, and they suppressed the confession, including the confession and videotape of the crime scene. In granting the motion, the trial court reasoned, and they have a reference, makes it clear that once a defendant asks for an attorney, all interrogations must cease and the police cannot initiate questioning unless the defendant voluntarily reinstates the conversation. Now, I'm curious to see how this got overturned. The state of appeal ruling of the trial, the court of appeal converted the appeal to a writ application and denied the writ 2-1 decision, finding the issue turned on credibility determination, and the trial court was in best position to make the determination. The state filed an application for rehearing, which was not considered in a 2-1 decision. We granted, I can't pronounce that word, on this trouble, issuing to further examine the legal requirements of Edwards' prophylactic rule. You know, I don't, how are they able to overturn this? So they're saying that the lower court should have analyzed the statement before granting the motion to suppress. So they're saying not to do with the credibility of the witness or even what the witness saw, but may I call a lawyer or can I call a lawyer? They should have analyzed this statement before granting the motion to suppress in the context of whether it was a proper invocation of defendant's right to counsel. So what they're saying is it's not whether she asked for it or not, it's the words that she used, was that invoking her right? And this statement is clear and unambiguous under the circumstances so as to put a reasonable police officer on notice that the defendant was invoking the Miranda rights to counsel during custodial interrogation. We recognize that this is troubling and difficult issue. It can be seen from our federal and state jurisprudence. There are wow, they really went all out with these words. Can invoke one's right to counsel, and there are different shades of whether one invokes one's right. While we find this issue is difficult and troubling, we are guided by our federal and state jurisprudence that have developed standards that aids us in determining whether a defendant sufficiently invoked the right to counsel. I don't know how many of you find this interesting or the cadence in which I read it to be worthy of your time, but I do think it is quite interesting that they ruled it wasn't admissible, and then it seems that it was overturned based on the wording she used. And in my opinion, I think that is invoking your rights when you say that. Not that I'm rooting for her, as you know. Let's see what their summary is. In accordance with the rule, as a matter of law, we find the defendant's statements were insufficient to invoke her right to counsel. The suspect must articulate her desire for counsel clearly and unambiguously, such that a reasonable police officer under the circumstances would understand the statement to be a request for counsel decree. For the foregoing reasons, we reverse the rulings of the lower courts. Defendant's motion to suppress are hereby denied. This case is remanded to district court. Further proceedings are consistent with the views, and that would have wait a minute, what's this? Supreme Court of Louisiana. Is this another overturning? I didn't check this part. What? Oh, it looks like it was overturned by, I guess, the Supreme Court, a higher court. Supreme Court of Louisiana. Oh, it was. Wow, okay. So, yeah, we have, I think, going through the motions of 3 courts, if my understanding is correct. This is the Supreme Court of Louisiana, State of Louisiana. And then this is the next chapter. It also is Supreme Court of Louisiana, but 12402. And this is also 12402. Okay, I'm going to pause this and check this out. Hold on. Okay, so I just paused and read. It's just a continuance that it should not be suppressed. They just went on to add a little bit more detail. So they clarified what actually happened, where she said, so she's by the police car and she says to her friend who's there, should I call John, who is her father-in-law, who is an attorney? And her friend said yes. And the police officer said, no, you don't need this. And so she never said, I want to call an attorney. She just said, should I call John, who is her father-in-law, who is an attorney? And the friend said yes. So it seemed that, and the police officer would have had no idea who John was. And when she got to the police station, they read her Miranda rights again, and she never invoked her right to an attorney, and they interrogated her. So it's not the smoking gun that I thought maybe we would find. Anyways, I think of Mr. O'Shea is there. She's denied some type of victim advocate. You literally have a woman who adopts 2 children, who has major issues. She with her bare hands smashes a 2-year-old's head into the wall 3 times. And then 20 years later in a parole hearing, she's saying things like, it's not his fault. That's what I would tell him. It's just absurd. It's sick. And, imagine if a man had done it. Would they feel differently if it was a man? I think it's a fair question to ask. But hey, if you didn't see it, you wouldn't believe it. And I really just feel like it's an injustice. It's an injustice. There you go.